If you are dissatisfied with a criminal judgment and want to appeal, what things should you look out for? Welcome to this segment on appellants in criminal litigation. Let us answer your questions. Preparing for an appeal. First of all, who can appeal? The defendant, their spouse, or their agent ad litem can all file an appeal with the court. Suppose the defendant has consented to appeal in their own interest. In that case, their agent ad litem or defense counsel in the original trial can file an appeal on their behalf. The defendant's spouse and agent ad litem can also file appeals independently. Victims and complainants, unsatisfied with the judgment, may submit reasons for petition and request the prosecutor to file an appeal. Is my case eligible for appeal? After the first instance, in principle, all cases can be appealed to the second instance court. Generally, cases in the second instance court involving certain minor crimes that are inappropriate for appeal will not proceed to the third instance court. However, suppose the defendant was acquitted by the first instance court with a judgment of not guilty, exempt, or granted dismissal from prosecution, or a jurisdictional error has occurred, but the second instance court proves guilt and overturns the decision. In this scenario, the defendant is entitled to appeal. Cases with at least one of the following grounds for appeal can be contested in the third instance court. Judgments based on violation of the law, including several conditions deemed as absolute violations, or rendered by a material breach of rules in a criminal procedure. How do I appoint defense counsel? You may choose a lawyer as your defense counsel. Also, your statutory agent, spouse, or third-degree relatives may independently retain defense counsel for you. Will the court appoint a public defender or lawyer for me for free? In certain situations, if you have not chosen a defender, the court will appoint one for you. For example, the court will appoint a lawyer for free if the defendant is either accused of a crime, carrying a minimum punishment of imprisonment over 3 years, or the case was heard by the High Court as the court of first instance. On top of that, if defendants are incapable of expressing themselves due to mental disorders or incompetence, are indigenous people under prosecution, or on trial following ordinary proceedings, or come from low-income households and have submitted their application for appointment of free counsel, or when presiding judges deem it necessary, the court will appoint a lawyer for the defendants. Filing your written appeal. If you want to appeal, you can file your written appeal with the court that issued the original judgment within 20 days of receiving it. The original court will submit your pleading to the Court of Appeal. To avoid missing the appeal period, you can first file your appeal after the announcement of judgment and provide your grounds for appeal within 20 days after the period elapses. How do I write a pleading of appeal? You can visit our website, and our AI customer service assistant can help you. Just enter a term in the search box. You'll find templates and examples to use as a reference. What you should write in your appeal pleading. 1. Scope of appeal. Write clearly which parts of the judgment you are dissatisfied with. 2. Court of jurisdiction. If it's a simple case, the appeal will be heard by the collegiate bench of the original court. Criminal case appeals should be filed at the court of the original instance. The court will forward the appeal documents to the appeal court after confirmation. 3. Concrete grounds for appeal. If you don't clearly state your grounds for appeal, the court will reject your filing. You can send it by post or deliver it to the court in person. If required, you may visit the legal service section of the court for further assistance. Preparing for court. The day you are set to appear in court arrives. If the court has agreed to remote proceedings, please refer to the Remote Court Proceedings Handbook in advance. For more info, you can scan the QR code in the top left corner. The courtroom is solemn, so if you do attend in person, please take care to dress appropriately to show you take your own rights seriously. On that day, remember to bring the summons, your ROC ID card or other identification, and any documents listed on the summons. Please check in early so you have time to find the courtroom. Also, please take public transportation if possible. Remember to log in a bit early if it's a remote hearing. There are 2 ways to register upon your arrival: at the counter or the check-in kiosk. After check-in, please find the appointed courtroom and wait for the court attendant to call your name. If it is not your turn yet, you can either stay outside in the waiting area or sit in the public gallery inside your appointed courtroom and listen to the current session. What if your session doesn't start on time? The judge may have taken a bit longer on the previous case. Like hospital clinics, courts hear several sessions every day, so please be patient. You can check the progress of previous cases on the court's website or on the LCD monitors outside the court. After entering the courtroom, please remain silent and be respectful. Court procedures and your rights. Photography, filming, and recording are forbidden in the courtroom. After your court session, you can apply for a CD recording from the court if needed. When the court session begins, the judge will first verify your identity by checking your basic information, including your name, date of birth, and residential address. In addition, they will make sure no part of your body has been restrained. Then they will read out the cause of action and inform you of your rights. You are advised to provide a clear statement in your written appeal and submit it to the court before the court session. In the course of the trial, the judge will ask you to explain your grounds for appeal. You can stick to the essentials, stating them briefly to help the session proceed more efficiently. The judge will ask you again for clarification if they have any doubts about any part of your statement. Don't worry if you can't fully express your opinion, since you can submit written documents as supplementary material. Please respect your opponent's right to defend themselves. Do not interrupt them. If you want to object, please raise your hand and wait until the judge permits you to speak. In court, the clerk will transcribe the proceedings in brief. Everyone has a computer monitor in front of them to check the record simultaneously. If a typo or misunderstanding occurs, you can report it for correction immediately. During a trial, defendants have the right to remain silent. You can choose not to answer when questioned, as you shouldn't be compelled to make statements against your will. In the preliminary proceeding, the prosecutor will introduce the facts of the crime. Then the judge will ask you to explain and refute what you have been accused of. The judge will ask you if you wish to express opinions on the evidence and facts described by the prosecutor. Both you and the prosecutor can ask the court to investigate additional evidence, and the court will decide the scope and method of investigation. Also, the judge will sort facts and legal issues between both parties into undisputed and disputed. During the trial process, the prosecutor will explain the cause of action, and you can respond. At this time, both parties will cross-examine relevant witnesses and experts to verify the evidence obtained in the investigation. Once the evidence has been investigated, you and the prosecutor will debate whether you are guilty. Then the 2 parties will discuss sentencing. The judge will ask you to make your final statement. If the court still needs to consider your case, the judge will immediately inform you of the next court date and location. If the judge thinks the evidence has been investigated sufficiently, they will announce the conclusion of oral arguments. The judge will then choose when to read out the judgment. They will confirm the crime and the sentence if you are found guilty. You do not have to attend court to listen to the decision. The court will release the conclusion of the judgment the day after its announcement, and you can find it on the Judicial UN's website. The court will send you a copy of the decision so you can understand the reasoning and conclusion. Appearing in court is not as difficult as you might imagine, so let's protect our rights together.